Hello, I'm Kelly Allen. I'm going to discuss with you asset protection for single individuals. And when I say asset protection, I'm talking about a situation where a family member who is unmarried is in need of long-term care in a skilled nursing facility, and we need to apply for Medicaid to pay for the room and board at the skilled nursing facility. So, in a previous segment, we discussed that one of the requirements for the Medicaid applicant is that he or she has to have no more than $2,000 in countable assets. So, if you go down to social services and ask about long-term care Medicaid, they're going to tell you to spend down. You're probably familiar with that term. And what that generally means is move into the nursing facility, privately pay for as long as you can, and then when you're completely out of money, come back and see us, and then we can help. So that's one way to qualify for Medicaid, but it's not the best way. What we do is work with family members to try to protect as many of the applicant's assets as possible and still have them qualify for long-term care Medicaid. And we do this by working within the Medicaid allowable regulations. So the ideal situation is we want to be able to either use the assets for something that is going to be beneficial to the Medicaid applicant, or to at least be able to get a portion of the assets set aside that's over in someone else's name, so that once the individual is receiving Medicaid benefits, that there is still money available to use to supplement other things that they may need that Medicaid is not going to be paying for. So with regard to the home, if the Medicaid applicant owns a home in his or her name and it's the primary resident, then we can almost always protect that home from a state recovery. Now, we can get the person qualified for Medicaid with the home still in his or her name, because that's an exempt asset like we discussed earlier. But then the issue becomes, after that person passes away, if we don't do anything with the deed, then the home will go into the probate estate, and Medicaid will place a lien against the estate to recover what Medicaid paid on care for that individual. So in actuality, the home could wind up being lost at a future date. We can prevent that by having a new deed prepared before we ever file for Medicaid. And it's special language. It's a special type of ownership. So we have the Medicaid applicant gift to someone else 1% of the home. The reason we want it to be 1% and not the entire home is because of the look back period and gifting penalties that we discussed earlier. So if your mom, for instance, gives her $200,000 home to you, just does a new deed and puts it completely in your name, that has the same Medicaid effect as if she had written you a $200,000 check. And that's going to result in a huge penalty period. However, if she gives you 1% of the home, then it's like she wrote you a $2,000 check. That's going to amount to a few days penalty period, which is not a big deal when it comes to Medicaid. Then the other magic language is as joint tenants with right of survivorship. Now, not all states have this type of property ownership, and not all states have the same Medicaid regulations. So I'm specifically talking about the current law as it exists in North Carolina. So in North Carolina, if you own a home with someone as joint tenants with right of survivorship, what happens is when that 99% owner passes away, in this example, that's your mom, and you are the 1% owner, by operation of law, you absorb her 99%. So you become the full owner. the home never goes into the probate estate. Therefore, there's nothing for Medicaid to attach a lien to. So that protects the home indefinitely. Now, certainly it's possible that those laws would change in the future. Other states have laws that make that impossible to do, but it's quite possible, and we do it in most every case we handle for North Carolina. The other thing you can do and will commonly recommend is to exchange a non-exempt asset for an exempt asset. And we discussed this a little bit earlier, where you're taking something that counts, like money in the bank, and purchase something that doesn't count, like a vehicle or an irrevocable funeral contract. Then the other common thing that we do if we have significant assets that we're trying to protect, we've already taken care of the home, we've already exchanged non-exempt for exempt assets, is we do strategic gifting. And it's a little bit of a complicated process, but in general, we are able to have the Medicaid applicant gift a portion of his or her assets and then loan a portion of his or her assets and utilize a Medicaid compliant promissory note. The effect of this, there are a lot of factors that are involved, including the person's income and the private pay cost of the facility. But in general, if we're dealing with a single individual, we can usually protect, meaning keep or preserve, about 30 to 40% of the individual's assets, plus the home, and still achieve Medicaid eligibility. So there's a lot that goes into it. These are general concepts. The main thing for you to be aware of is that there is a lot that can be done. So if you have a family member who is needing skilled nursing care, don't just move in and start privately paying and wait until you're out of money. Come see us when you first know that someone is going to need the long-term care, because there's a lot that we can do to help you.